Okay, thanks, John. Thanks to all the organizers of this fantastic conference. So this is a joint project with Yaron. It's about a relatively new phenomenon in corporate governance. We're seeing more and more companies adding directors with specific narrow types of expertise to their boards. So we have companies announcing we added a cyber director, or a climate director, or a DEI, a diversity director, okay? We think it's an important phenomenon, and here's what we have to say about it. So I'll start with the 2-minute kind of Cliff Notes version of the paper, right? The first thing that we try to do most basically is just to provide initial evidence, give us some sense about the scope and the magnitude of the change. So we hand collect data from companies' proxy statements over the past 6 years, and we document how big the change is. We show that companies disclose much more heavily, put much heavier emphasis on the skill sets of their directors in their reporting to the investors, and we show that companies are adding directors with specific types of expertise. So for example, the number of directors who are identified as cyber experts in the S&P 500 jumped 20-fold just over the past couple of years. Now, is that a good thing? Is that a bad thing? This is where the second part of the paper comes in. I think it's the counterintuitive part, because it's kind of intuitive to think of director expertise or types of board expertise as an unalloyed good. What can be bad about adding types of expertise to your board? But here we build not just on the literature on group decision-making, also on interviews that we had with board nomination committee members and outside search consultants, the headhunters, to highlight potential drawbacks of this trend. I mean, in a nutshell, the point is that trying to address first-order problems like user privacy or pollution or discrimination through focusing on a specific skill set by a specific director is not necessarily productive. All right, you might reduce the effectiveness of board discussions on other topics, such as core business strategy topics. You may actually even reduce the effectiveness of board discussion on that specific cause that you're trying to promote. So if the company adds a diversity director or a cyber director, it doesn't mean that the company will perform better on diversity and cyber. Sometimes it means the opposite. This brings us to the third and final part of the paper. It's a law review paper. We have some policy discussion, policy implications regarding the desirability of legal intervention, if at all, the type of legal intervention that we need in types of director skill sets. And we try to assess how these trends will affect the way that courts evaluate director liability going forward, whether there will be differences in the way that they assess liability for expert directors or for specialist directors versus non-specialist directors. All right, so this is basically the paper in a nutshell. Before we fill in the details, let me give you 2 minutes on the background. And it will literally be just 2 minutes because we have here a crowd full of specialists in corporate governance. So the starting point is that boards matter, okay? They play an important role in advising and monitoring managers. And the question is, when will boards be effective in playing these roles? Now, when we corporate legal scholars treat this question, we usually focus on directors' incentives. We count how many directors are independent. We count how many firms they have the roles of the chairman and the CEO separated. We think that at the same time, everybody realizes that even a board full of independent directors will not necessarily be effective in advising and in monitoring managers, right? Because even if you're the most motivated, publicly spirited director, you still need to have some type of skills or experience in order to ask the right questions and process the answers and anticipate future problems and so on. So it's not just about incentives, it's also about ability. But now the relevant question becomes, what types of expertise do we need around the table in our boardroom in order for the boards to be effective? Now, historically, we thought of boards as consisting mostly of former CEOs in the 60s and the 70s. They have a lot of expertise in running businesses on a large scale, but that is starting to change, partially through the ESG pressures that we talked about yesterday, partially through the rise of compliance and so on and so forth. Oh, sorry. So we have a couple of papers over the last couple of years dealing with the increased involvement and accountability of corporate boards in ESG issues. We have some papers about how directors increasingly factor ESG factors into when they design executive pay. We have some papers talking about how boards increasingly restructure their committees and their charters to assign specific responsibilities to specific ESG topics, right? And what we add to this literature is that the same ESG pressures are also starting to change board composition, meaning how companies select individuals to sit on their boards to begin with. And we identified several vectors that push large companies to add directors with specific types of skill sets. So the first, most intuitive, I think, conduit vector pressuring companies is regulation. And the classic example here is the SEC Cybersecurity Disclosure Proposal 2022, which contains a provision that requires company to disclose whether they have a cyber expert on their board or not. Second conduit, also intuitive institutional investors, from the policies, the guidelines of the largest asset managers to kind of more targeted campaigns by socially minded activist shareholders. Third conduit, more surprising, litigation, such as the one following the Boeing 737 MAX debacle. It's a famous director oversight duty case, ended in the biggest ever settlement in such cases, $240 million. But for us, the most interesting point about this settlement is that Boeing was required to add a director with expertise in aviation and 2 additional directors with expertise in either engineering or product safety. So I want to pause here for a second, especially for the non-lawyers, to explain how unique that is. In the past, to the extent that derivative settlements required company as part of the give to introduce changes to their boardroom, it was about adding independence. We commit that going forward, at least half of the directors will be independent. We commit that going forward, this specific committee will be comprised only of independent directors. Now we're seeing courts pressuring companies to add specific types of expertise. So we have all these mounting indications, several vectors pushing companies to add specific types of expertise, but we don't really know how companies respond to these pressures, and we don't really know how the company's response will affect the way that companies behave going forward. So this is where our independent study kicks in. So we hand collect and we code all the proxy statements of the S&P 500 companies in 2016, 2019, 2022. We do the same for a sample of S&P 600, the smaller cap companies. And there's no, I'm anticipating a little bit, but there's no standard, there's no benchmark in how companies have to disclose director skill sets. So that meant for us sifting through different components of the proxy statements. But as you go through the years, increasingly it becomes easier because increasingly companies are adopting these skill matrices that you can see here. And in a skill matrix, the directors are the columns and the specific skills are the rows. So once a company adopts that skill matrix, it's like a one-stop shop for you when you try to collect data on changes in directors' skill sets over the years. So here are what we think is the 5 most interesting findings from this data set. The first, clearest finding is that companies are putting much heavier emphasis on disclosing to investors exactly what types of skill set do the directors have. Best way to illustrate it is the example that I just gave, shifting to image-based formats. 2016, only 14% of the S&P 500 used the skill metrics. Fast forward to 2022, 60% of S&P 500 using skill metrics. Nowadays, it's much bigger. We have Fabrizio, he's the current expert on skill metrics. He'll probably give us some interesting nuggets in the discussion. Okay, it's not just that companies disclose more about the director skill sets, it's that companies disclose about more types of expertise. So if you're a company in 2016, you have a skill metrics, you probably had like 5 rows there. Financial expertise, legal expertise, marketing strategy, whatever. Nowadays, if you have a skill metrics, it's probably like 10 rows because you also report about sustainability or cyber or what have you, okay? Beyond disclosure, companies are also reporting more directors being added who are specific experts in specific types. So we're seeing here 10-fold or 20-fold or 30-fold increase in the number of directors on DEI or climate or cyber. Cyber in 2016, only 25 directors of the S&P 500 identify as cyber expert. Fast forward to 2022, 723 directors identify as cyber expert. Most of the jump happened over the past couple of years. But it was precisely at that point when we started collecting the data where we became skeptical, okay? Because we know just how glacial changes in board compositions can be. Yaron wrote about it in a previous project. Okay, and so we started, instead of aggregating the numbers, we started looking director by director to understand what's going on here. And what we saw was also telling about the limitations of our own data set. Because once you go director by director, you realize that a large part of the change is not necessarily changes in expertise, it's changes in disclosures. So if I'm a veteran director, I was on the company in 2016, and I am a cyber expert, the company didn't report cyber expertise back in 2016. The company started reporting cyber expertise in the boardroom only in 2021. So that will count as our data, and in our data as a change in expertise. Some of the change is also the fact that I acquired expertise over time. So I'm a veteran director. I was on the company in 2016. I'm not a cyber expert. But in 2021, the company is sending all of us to a weekend cyber boot camp or something like that, training. And now everybody's checking the box as cyber expert. And a not insignificant part of the change is also adding directors from the outside just for them being cyber expert, okay? So it was interesting for us. We wanted to do a further, deeper dive to understand the relative weight of these different factors. So we read through the bios, the biographies of each one of these 723 cyber directors. What we found, several things, but the most interesting thing, I think, is that less than 40% of them in their bios use words such as technology or cyber, refer even to the technological expertise. So what this means to us is that for these people, cyber technology, this is not the core quality or reason for why they are on the board. They have some experience with cyber. Maybe they sat through board meetings where cyber was discussed, but they're not cyber experts in the day-to-day definition of the word. And this brings us to, for a law review paper, probably the most important point, which is the quality of director expertise disclosure is not ideal. Okay, there's no standard, there's no benchmark, there's no comparability. Companies are simply sending you a questionnaire. You need to check the box. Everybody checks whatever box they want. And we have in the paper many examples of directors sitting on several boards. In one board, she is a cyber expert. In another board, she is not. In one board, she is a climate expert. In another board, she is not. Okay. We also have some interesting findings about the differences between large cap and small cap companies in how they respond to these pressures to add specific expertise. I'll leave them to the Q&A just in the interest of time, because I want to get to the second part of the paper, which was evaluating whether this development, the fact that companies are treating board expertise differently, could it be a good thing? Could it be a bad thing? How would it turn out to be? Okay, intuitively, why wouldn't it be good? All right, it seems like a natural reaction. We heard yesterday, companies are facing increased regulatory and societal demands, all these ESG pressures. Newer topics that weren't on the board agenda appear on the board agenda, you know, so why don't bring in more experts on these topics to be able to better address these issues that are now on the board agenda. So we wanted to highlight, that's the intuitive point, we wanted to highlight the less intuitive drawbacks, potential drawbacks of this new trend. First and most basically, it's kind of a basic supply and demand thing. The fact there's a sudden uptick in demand for, say, cyber expert director doesn't mean that supply will rise to meet the demand, at least immediately. Okay, the pool of good director candidates, people who are qualified to be directors on large companies, S&P 500 companies, who also happen out to be like a climate change expert or a cyber expert, is very, very limited. And so almost by definition, if all the companies are rushing to add this type of directors, perhaps because the SEC disclosure rule, then some companies will get perfect directors who are also cyber experts, but some companies will have to compromise on their director selection criterion, director onboarding process. You might add a director with cyber expertise, but less than ideal interpersonal skill, less than ideal understanding of the business, less than ideal bandwidth, okay? And so you might end up improving your discussion on cyber or the climate, but you may reduce the effectiveness of both discussions on other core aspects of the business. In fact, you might even reduce the effectiveness of both discussion on that specific topic. And this is something that came to us from the interviewees. I think almost all of them mentioned, unprompted, without of course talking to each other, a dynamic that they didn't call it like that, the psychologists would call it authority bias. Meaning that once we appoint someone who is considered a cyber expert or the climate expert, the other directors become too differential, too unwilling to invest in learning this topic, listening just to what the perceived expert has to say and doing what he or she says. Third potential problem, to the extent that companies inject these new types of expertise to the boardrooms by adding new directors, over time, these pressures will make companies grow their board beyond its optimal size. Now, of course, we know that the literature, there's no magic number. There are many trade-offs here to board size. But the one thing that we worry about here is, remember, most of the time, this is not like a natural firm-by-firm reconfiguration of the board. These are just hasty responses to external pressures, disclosure, litigation, legal exposure, institutional investor, one-size-fits-all policy, and so on. Fourth potential drawback, to the extent that you care about racial or gender diversity in the board, this trend could interfere with the efforts to promote, say, gender diversity. For example, if you're going to a pool of candidates like cyber experts that is predominantly male, it could interfere with efforts to promote gender diversity. Fifth potential drawback, this might be some board washing, you know, a la greenwashing going on. Okay, if companies are facing pressure to change the way that they treat employees or the environment, you can either actually change the way that you behave, or you can check a box in a skill metrics, and the latter is more, it's easier, right? So it could very well be, channeling Emiliano from a previous conference, it could very well be that board washing is not bad if you think that the regulatory pressures are populist and are bad. But that goes to the last point, which is we can't really say unequivocally that this new trend is either generally bad or generally good. Okay, there are advantages, there are disadvantages. What we can say is that there are two factors that worry us. And that the first factor is what I just said. It's not a natural reconfiguration firm by firm. It's usually one-size-fits-all hasty reactions to external pressure. Second factor is the cheap talk environment. The disclosure environment is very low quality. Everybody discloses what they want. The combination of these two factors worry us that the disadvantages of new types of expertise will outweigh the advantages of new types of expertise. So that brings us to the policy implications. Perhaps the main policy implication is to rethink the desirability of intervention in types of board expertise, right? Not all additions of expertise are created equal. Sometimes, or in some firms, where you add a safety director or a cyber director, it will add value. In other firms, it will not. In the same firm, it could add value in 2022 and destroy value in 2024. To the extent that regulators decide to intervene, we suggest that they do it not necessarily by nudging all companies to add specific types of expertise, but rather by ensuring more comparability, higher quality of board expertise disclosure. We also have a discussion in the paper. I think I'll skip it here for the non-lawyers, not to bore you, because it's very doctrinal, about how these changes may affect the way that courts assess director liability. Instead, I think I'll talk about one anecdote that kind of sets up the stage for Fabrizio and the rest of the discussion. I mentioned a couple of times the SEC proposal, cybersecurity disclosure rule, requiring companies to disclose whether they have a cyber expert on the board or not. When we read the proposal, we noticed that it didn't mention a single academic study. When we read the transcript of the court discussions in the Boeing case approving the settlement, there's no discussion whatsoever on whether adding 3 directors with these specific types of expertise will be good or not. So that's a classic law review paper for us. We have the lawmakers assuming that doing something will improve corporate governance without really having any evidence or without really factoring the many factors that go into that. Okay, now the next step, and we're already working on some spin-off projects, is to try to figure out the antecedent, what are the causes of specific companies at the cross-sectional variation, what companies add directors from this expertise, what companies add directors for that expertise, is it correlated with companies' risk disclosure, liability disclosure, and so on and so forth. There's also some studies to do on the consequences, like if you add a cyber expert, how does it correlate with being involved in cyber attacks in the future? We think that these will take 2 or 3 more years until the evidence accumulates, because I told you this is just a last 2 years kind of development. So we're very much looking forward for a suggestion in that regard. And to echo Jill from yesterday, we invite the finance people to join this conversation, and Fabrizio will kickstart us. Thanks.
All right, does it work? Yes. Good morning, everyone. Thanks to Roy and Yaron for a very interesting paper. We very much enjoy reading it. And thanks to the organizer of the conference. They always treat me well, historically. The last time I was invited to discuss a paper was a paper on gender discrimination mutual funds by Renee Adams. I never done research on gender discrimination or mutual funds, but also happy to go to Boston and discuss the paper. This time they pick a topic closer to me. And as an additional gift, a law paper. No regressions. I don't need to talk about fixed effects and identification. It's actually very liberating. So I'm super, super happy with that. Okay, so you presented the paper very well. In fact, I didn't prepare a summary because I assumed you would do a good presentation. It falls into the big topic of monitoring versus advising roles, very important. If you go back in history, I think expertise was the key focus in the 70s when we had insider-dominated boards. Then in the 90s, we started pushing for board independence from management. And then I think there was a push for accountability, the notion that it's not enough to be independent, but you need to be accountable to shareholders, all the work by Lucian and others on shareholder voting, proxy access, majority voting, and so on. And now we're kind of back to expertise in the last, I think, 15 years. And I think it starts actually before the ESG movement with, the Lehman Brothers case, where, all of a sudden people realize, wow, the board of Lehman Brothers did not have anybody with real experience in risk management, financial expertise, and so on, right? Now, ESG has made this even more important for the reasons that you mentioned, and so the pressure to have expertise on climate, DI, cyber, and all the things mentioned in the study. So the study basically looks at this phenomenon of the so-called specialist directors that have expertise in these areas, what are the, the risks, the benefits, potential policy implications. I like also the fact that they have a mix of some empirical data, some interviews with practitioners, multidisciplinary, they borrow on organizational theories and so on. So there's a lot to like about the paper. Very timely topic, of course. I was on a panel in Miami a few weeks ago on how artificial intelligence is gonna challenge boards, and all the board members there were talking exactly about what you're talking about. It is, we don't think we need to bring a specialist. We need to learn about this and be able to ask questions ourselves, because that's we need people on the board that can participate in everything. So kind of resonating a lot with your arguments. Also, I just saw on the Society for Corporate Governance newsletter a Spencer Stewart survey. The title, well-rounded directors favor over issue expertise, right? So very much in line. And there are a lot of quotes that are very similar to the one you collected. Also, how do I know it's an important topic? I'm working on it, so it must be important, right? I mean, that's my take. I've actually, as you mentioned, a paper where we collected all the skill matrices data, not just to examine this specific issue, but more generally how the optimal combination of skills on boards and various issues associated with the board literature that one can revisit in view of this data. So my comments will be in 4 areas. First, I will try to draw a distinction, and these are all, I think, all comments that are mostly suggestions to potentially rewrite some of the parts of the paper. It's up to you. But draw a distinction between specialist directors and directors with special skills. I'll mention that in a second. What's unique about these skills compared to many other skills that have always been on boards? Okay, what's really unique about these? Let's call it ESG for simplicity, but it's not necessarily ESG, all of them. Policy implication, we'll not talk about the very interesting discussion you guys had about director liability, because there's a lot of experts on that. I will not go into that. But I will focus more on the disclosure side as an accounting researcher. And then maybe some suggestion, where does this pressure come from? Okay, I might differ a little bit from you guys on the answer to that. So the first topic, I spent quite a bit of time on this, is this distinction between specialist directors and directors with special skills. Meaning, is this about really specialist directors, or is it about generalist directors that happen to also have these skills? Why do I raise this question? So he mentioned that they got this data where in 2022, about 723 directors have a cyber skill in the matrix, okay? And 570 of those are newly added cases, which they analyze. So what do they see? The 348, so more than 60%, these are cases where a company did not consider cyber a skill important enough to be in the matrix 3 years before. Now they add this column with the cyber, and some existing directors happen to have it, okay? So you cannot almost dismiss this as it's about a change in disclosure, about a change in reporting. But what it's telling me is that there are existing directors that already had those skills, according to the company, or they recently acquired it. Maybe they did some training, maybe they sit on boards or are executives in companies that are facing those issues. So by the time the company considers cyber enough to be a skill in the matrix, it turns out that in 60% of the cases, they already have the in-house answer. Another 4% is existing directors that did not have this skill 3 years before, and now they have it, presumably via some training or some experience they had in other companies. So when you put it all together, 65% of the answer comes from directors already on board, okay? So I just wanted to limit or to define a little bit the problem. It is 35% are newly added director with this expertise, okay? And I will say why this distinction to me is important. Now, even this 35%, I would say these is an upper bound of the number of specialist directors. In what sense? Well, what I would like to see, and maybe you guys can collect those data for this 199, is how many of those are also people that have already board and executive experience in other companies. And they also have, the cyber expertise. So you go outside, but now you bring people that have been on boards before. They know how to contribute to the board discussion overall. So a lot of the concerns that you mentioned for these guys are probably not really significant. So the group that instead is closer to what you talk about in the paper a lot is the so-called rookie directors. Essentially people that have very limited board or executive experience. They're really functional specialists, and now they are brought to the board to talk about cyber or to talk about the science or climate, but they never really talk about strategy, business models, organizational planning, and all these things, right? So that seems to be the spirit of the paper, seems to be about the last group, but I think it's important to, first of all, quantify that it's not as big as it might look like. So that's some implication of this, though. So the first one is that I think you could rewrite your promise and peril section distinguishes these three groups. Existing directors, they already have those skills, maybe because they acquired via experience, via training and so on. New directors that come in, but have been on board before, so they are not subject to some of the perils that you mentioned. And then the new guys that are really kind of new to the board as well, and they may be the ones that are more susceptible to the problem, right? So for example, in the peril section, where you talk about individual attributes, so the fact that can they contribute to the broader discussion, that it seems to be more a problem for the specialist rookie director than for the other two groups, right? And so on, if you go through all of them, for example, the board packing, that would not be an issue if they already have a director in place, right? So maybe you can kind of carry that distinction through the discussion of the five perils. Board washing as well, I didn't think too much about it, but maybe adding a new director, maybe less likely to be board washing because you're committing to bring somebody new that will be scrutinized and so on. Whereas kind of just saying somebody did a course with an ACD on cyber, that might be kind of more like, closer to washing. So again, this is just something you can exploit to make the writing a little more nuanced in that sense. Another example in the promise section as well, right? Because the benefit of breaking the groupthink, of breaking the escalation of commitment bias would only apply to new directors coming in, right? If it's existing directors, then you don't have those benefits, but you do have all the other benefits, providing knowledge, being proactive, communicating with stakeholders. That can be done regardless where the director comes from. So this is just to separate these groups in the writing. The second implication of that is it made me wonder, are we just looking at a very temporary one-time shock? The paper suggests it's a big trend. I'm not so sure it's likely to continue, though, because it seems that existing directors are all quickly acquiring this knowledge. I think if you ask any director today, what do they know about climate or cyber compared to 7 years ago, they will all tell you, we know a lot more. They may not be technical experts, but their expertise is going up. So I think more and more companies will solve the problem kind of internally by acquiring the knowledge, whereas the need for going to somebody outside the director pool and get their expertise on the board might actually be reduced. I don't know the answer to that, time will say, but you may allow for that possibility if you make that distinction. And finally, the other reason why all this is important is because I think it would be good to have a real section on how to acquire expertise on the board, right? So you have a very good discussion in the paper about the benefits of having expertise on the board compared to going to outside consultants, right? So, and the idea is that if you have expertise on the board, it's a continuous process. You're always monitoring the problem, you're always reassessing the risk and everything, and you're very proactive. Whereas if you go outside on an ad hoc basis, you might forget about the problem after the meeting with the expert and so on. So that part you do very well, the hiring consultants, or some companies use an advisory council of experts and so on. The expertise on the board, I think that's why you could draw this distinction between going for somebody new on the board or training, in some sense, the guys inside, right? And that would be training, certification, but also presentations from management, from the internal expert, creating a subcommittee and tell them, go and learn about this, and so on, right? So I think distinguishing those two would be helpful on in terms of different ways to acquire expertise. Now, how does that all tie together in the end? To me, is that maybe the paper, and strategically I can see why you will do that, but it feels a little bit too much of a story where all of a sudden there's these outside forces, they are forced to go outside and get these experts and bring them on the board, and it's almost by definition suboptimal, the process you set up. Now, in the language here, you are much more careful, but I feel like if you rephrase the problem as there are different ways of acquiring expertise on the board, then the natural expectation is that on average, boards should do it optimally. Some of them will prefer to develop inside because they get more time. They can spend in training programs. They can bring experts. Others will prefer to go for somebody new, and they may So the chance that this will become a problem I'm not saying it's not going to happen, but it's become a narrower group of companies that will be forced into this corner solution of getting somebody with no board expertise and creating all the problems that you identify. So I think the problem is there. I just feel that the magnitude may not be as big as the paper makes it. And it's more consistent with your data, right? Even for cyber, that is a very technical expertise, 65% solve the problem without having to bring somebody from outside. And so in that sense, of course, also the policy implication might be different once you allow for boards optimally reconfiguring, do an optimal reconfiguration. That's the term you used earlier. Now, the second point is what is unique about this type of skills. The paper is not, I think, as clear as it could be about that. And what do I mean by that? Well, if I list here a bunch of kind of, somewhat technical skills that could be on boards, right? Marketing, digital transformation, supply chain, finance, accounting, and so on, right? So which of the skills that you cover are closer to which group of these? So the way I kind of put them together was, well, let's look at the first group up there. I put them in, I think, in green. Those, to me, are all like things that have to do with understanding the business model, the strategy of the company, right? If you do digital transformation, supply chain, you participate to all those discussions about the big picture of the company. Perhaps climate might fit there, depending on what we mean by climate. If it's a scientist that just tells you the science, maybe not. But if it's a sustainability expert whose goal is to redesign the business model around it, presumably he'd be a part of those conversations. Same for artificial intelligence. If the goal is to rethink the whole business model around it, that should be kind of a strategy level thing. Cyber seems more technical to me, more like data privacy, product safety, a little closer to finance, accounting, legal, and so on. Okay, so we may have different views where we draw the line, but I think it's important for the paper to kind of distinguish that, because the first group up there, we can't say that those guys will not be able to contribute to the broader discussion, right? One of the concerns that you have that is they're not speaking on their expertise, they're not speaking about anything else. There might be less of a concern for sustainability skills, might be more of a concern for cyber and other things. But the other reason why I raised this point, to me, is that if I go back to that list there is a lot of guys here that are not going to participate to strategy discussion, right? The accounting expert, the legal expert, regulatory risk, they tend to be functional. So in other words, there's nothing new about having a mix of skills on the board or generalists and a little bit more functional experts. It's always been the case, right? So, yeah, well, I can in this audience, I wouldn't be able to answer. If it was an accounting conference, I would have a joke for you, but boards, I know when I'm in a minority, it's better not to. So the point here is that boards kind of figure this out, right? Historically, they know how to have a mix of these people. So why shouldn't be able to figure it out this time? What is unique to these skills that changes what we have seen for such a long time? So right now it feels like the paper kind of saying that this is new because it's ESG stakeholder driven, but it's not really 100% clear to me what is new and unique compared to everything we've seen before. There might be some differences. So one I suggest to explore is the issue of advocacy versus expertise, meaning that you talk about the fact that in a couple of cases, activists push for, I don't know, a climate expert for an oil company, but the paper doesn't really build on that difference, right? Now, because if you start thinking about advocacy, then to me it's more clear why we might have an issue. That is, you have a director imposed by outside, truly imposed by outside, who is advocating a position, not bringing expertise. They are basically, and that changes to me all the list of promises and perils, because even authority bias will change, right? Because if you are there to push a position that I disagree with, instead of deferring to you, I'm going to learn a lot because I want to tell you I don't like what you are suggesting, right? So that seems to be something very specific to this set of skills, not to cyber, but at least to climate or DEI. That would be, right? So maybe that's something that could give, otherwise, maybe you're just saying it's a matter of volume. This is happening a lot faster, and that's true. And for so many new skills compared to accounting, legal, and so on, that kind of evolved over time organically. So it may be just kind of a matter of quantitative difference, not qualitative difference. I don't know how much you wanna push that this is unique to this set of skills. As an accountant, I have to take this on the disclosures because I think the paper is does not push for a specific mandate on what to disclose better, but it kind of says that we should standardize these disclosures more. I went through all those skill matrices. You are right, there is some kind of weird things happening there, but I would be reluctant to decide to request mandate something standardized, because this inconsistency, what you call inconsistencies, for us in accounting especially, these are the beauty of voluntary disclosures, meaning the number of skills, the type of skills, that's a firm-specific assessment. The beauty of the skill matrix is that board tells you, we think these 7 skills are crucial. There are others are good as well, but these are the important ones. And we think it's okay to have 2 directors with their skills or 3 directors with their skill because you may not want to have too many chefs in the kitchen for a given thing. So to me, that's really the company telling us what they think is the expertise they need. So defining expertise that should be disclosed and so on, to me is a little, first of all, very difficult to do, but it will take away some information. So all of this is very, very specific. So I can see why John could be an expert for one company on a topic where they need that type of expertise, but may not have enough expertise in the topic for a company where that is a lot more crucial. So again, I believe you are right that there is a lot of cheap talk there, but I'm saying that I would be careful in imposing something from outside because it is very firm specific, and this is all literature in accounting of the disadvantages of standardization and this type of things. Yeah, so the beauty here is that you learn from that, but of course, cheap talk is always a concept, right? That's true for every one of the disclosures. We saw the first paper yesterday was basically about that, right? So, but I would be a little more careful. That said, you don't say in the paper anything like too specific. You just say there is inconsistencies there. That's true, and it would be nice to have something a little more comparable. Hopefully, will emerge as companies, kind of standardize with each other a little bit based on what the peers are doing. And finally, we just have a couple of minutes. Sources of pressure, you mentioned 3 of them. I think you may want to clarify the relative importance. I thought institutional investors seem to be the kind of most important here. Maybe clarify also the voting policies. You refer to voting policies, but I didn't know exactly what voting policies you have in mind. The litigation case is only one case. It's super interesting, obviously. But it's only one case, and I'm not even sure it's the reason why they added the director. Yes, they had to do it in response to the settlement. It's hard for me to imagine that Boeing would not add some experts in that area after what happened, even without the litigation. But that said, it's super interesting from a legal standpoint that this can happen. And then your third one is the disclosure mandate. Initially, I thought, okay, that's very minor because the SEC had this proposal to get to disclose if you're a cyber expert. It's not asking you to add the cyber expert, but by asking you to disclose, it's kind of putting you pressure to do it. But the proposal didn't go through, so it didn't seem to me that important. But I actually came to agree with you because as I read the final regulation, it talks a lot about board oversight and especially describe the process by which the board is informed about this risk, and having an expert is part of the process. So indirectly, I think it is putting pressure. I agree with you. And in fact, I would suggest that you also add as another example the SEC climate disclosure rule, because there the language is even more clear, how the board is informed of climate-related risk, to presentation from management, third-party expert, board members with expertise is one of the examples they give. So I think actually maybe the disclosure mandates are quite important in this process. And finally, I thought that maybe this is super obvious, but the main source of pressure would be consumers, employees, society at large, institutional investors, courts, SEC. They're just the channels by which that's manifesting. But I thought the ultimate pressure really comes from the realization by boards we need to change business models because that's the only way to be sustainable in terms of our consumers and so on. And so if you take that point of view, so again, maybe it's obvious in that, but to me should have been, because otherwise I still feel like it seems, oh, BlackRock, the SEC, and the judge came up with these crazy ideas. So I felt like, there's a little more on this would be good in the writing at least. And related to that, 0 minutes, the board, right? So you give very little credit to boards. We always like to criticize boards in terms of ability to self-reform. You say this is not a natural reconfiguration. They're doing it in response to pressure. I think that's really a little too negative view about what boards do. I think a lot of them have been adding expertise without that input, just on the realization that our consumers want us to do something different, our employees want us to do something different. So I think, giving a little bit, and that's important because at the moment you bring that board natural response, you allow for optimal responses. So you allow for the possibility that they will trade off cost and benefits and on average, perhaps do it right. In which case the problem you highlight could be, less crucial than you make it in the paper. But that's, I cannot prove that, but I offer this as suggestion to, to expand the writing a little bit and allow for these things. Thanks a lot.
So John, can I have a couple of minutes before the, so very quick, Fabrizio, thanks so much, super useful. Whether it's like a generalist with special skills or not, it reminds us of the finance and accounting crowd here. It was after the Sarbanes-Oxley introducing these nudging firms to add financial expertise. There have been all these studies about what were the consequences of adding financial expertise to the board. And to me, the most interesting finding from that literature is the cross-sectional variation between variants of financial expertise. If I recall correctly, the studies show that the positive outcomes came only when you added directors and when you added financial experts with actual accounting expertise, and not when you added financial experts that didn't have accounting expertise. So that speaks to some of the things that we discussed here on experience versus expertise and the definition. On whether this is just a one-off shock that would be quickly balanced, I don't think that's the case. I don't think it's going anywhere. So you might be right about a specific topic. So say that everything will go down quietly in the cyber experts area in 3 or 4 years. But I distinctly remember that the last interviews that we did told us something differently than the first interview. So the last interviews, if you talk to a search consultant now, they all will tell you, they ask us to bring directors who are AI experts. Right? This thing isn't going away. And we talked with the guy from the ISS. He said board expertise is the new board independence. Investors got everything they wanted from board independence. Companies are doing more on board independence than investors want. Now everybody is sitting with the skill set. And from a legal perspective, there's a universal proxy rules that allows investors to pick and choose directors. So everybody's going on the skill metrics. Everybody's saying, okay, you don't have any director who is an AI expert. So that's the next thing. 2027, there will be another thing, right? I don't think it's going away. What was the second point? The second point, okay, how do we distinguish between the different types? You're absolutely correct. I mean, we started calling it, we presented it with Stavros, I think. First, we call it ESG directors, which is very good for marketing, but it's not accurate because it's not necessarily ESG. And there are different types of expertise. Cyber behaves differently. Cyber is closer to financial expertise in your ability to define it. Being an ESG expert is very fluff. We don't know how we define it. The reason that we picked these 5 areas is kind of finance literature related. You know, we looked at the Renee Adams study, director skill set from 2018. They cataloged, if I recall correctly, the 18 skill sets of directors. And we didn't find any of these skills in this 2018 categorization. So we figured these are the new skills, let's focus on them. Last, sources of pressure. I have to do some legal speak here, so excuse me. It's not about one case. It's one case is the derivative settlement. There has been one of the most important developments in corporate law is the rise of director oversight duty or director oversight liability exposure in many cases. And this is actually one of the, I think, the most important part in a spin-off project. We try to look at how law firm memos circulating to their board clients after each of these cases, specifically telling them, you probably need to have some cyber expert because the cyber cases are coming and they're coming after you. Okay, so the change in the law in that regard, regardless of that specific settlement, all the legal advisors to boards are telling them, you need to add those experts. Right?
Okay, great. We'll take 3 questions to start here. Let's start with Jill Fish.
Feel like you're still sort of torn between whether this is a paper about specialist directors or ESG directors. And in particular, I feel like the start of the debate about specialist directors really was the financial experts in Enron. And even though you mention it in the paper, there's a whole lot of finance literature on, you know, what difference they made and so forth. And, you know, it'd be helpful to think about that, especially since it's mandatory, so the disclosure is at least better there. Even prior to that, as sort of companies started to globalize, there was this push for directors with globalization expertise, and there's some literature on that. So, you know, if it's specialist directors generally, that would be helpful. Disclosure and whether companies are changing who they have versus what they say about them is super important. An interesting anecdote in the Board X disclosure of director characteristics, only in the last 2 years have a significant number of companies started to disclose director sexual orientation. Obviously, that's in response to things like the NASDAQ rule and the now defunct California rule. But I don't think it's because they suddenly went out and found gay directors. It's because there was pressure for those directors to publicly disclose their sexual orientation, and it had legal consequences. Third thing, specialist directors, to my mind, raises the sort of classic firm versus market choice. Do you go out and hire consultants to bring in expertise, or do you bring it within your corporate governance structure? It might be interesting, at least alluding to that choice, that question.
Just quick on super interesting project. And in order to tease out what's going on and distinguish Fabrizio's board self-reform optimization story from a more external pressure-induced story, you could also look at what adding new board members with skills does to other metrics like board diversity. Because that could tell you that probably if it's really adding also board diversity, but it's just not a straightforward optimization issue. It might be something that is more externally driven. And it's always a bit hideous to say, you have to add more data, but I think you don't have to do that because Slava Foss from Boston College has a fantastic data set on board diversity across exactly your observation period. And that could help you tremendously in teasing out what I suggest.
Okay, let's do one more Stavros.
Thank you. So my question or observation, as you presented it, is that there seems to be a tension between people that have fake expertise, if I can be blunt a little bit about it, and people who have real expertise, but the discussion is about, do we actually need that expertise or not? And I think it's important to tease out these two explanations. With apologies to me, I wouldn't be in favor of faking things, because it's kind of, I think, bad practice for the board, and it gets you into all sorts of trouble anyway. So that's kind of a tension that I would consider unpacking a little bit.
Of maximizing feedback, minimizing my time, I'll just say all great points. I'll just say one quick thing. Teasing out the effects, we started and then we stopped a little bit. There's this Adriana Robertson paper about gender diversity, showing that on things such as board packing or diversity, some of the trends that you see in the first 2-3 years reverse after 4 or something like that. So if we feel about board packing and you add 2 female directors, the size of the board jumps from 8 to 10, then you wait, and after 4 years it goes back to 8 or something like that. So.
We can talk about these 2 papers later.
Thank you for your great paper. It was really interesting. I'm curious about whether your analysis or the observation may affect the doctrine of oversight duty. I mean, under the current the Kermark doctrine and other corresponding doctrines of other jurisdictions, the doctrine does not distinguish the directors based on their expertise and treat these board members as if they are the homogeneous ones. So each director is expected to do their oversight role irrespective of their responsibility. But if we accept that each director has its own the expertise and that's why they were invited to the board, then probably we may expect different roles to the oversight roles to each member of directors. So would it be fair, for example, if there's any cybersecurity incident, then the cyber expert director has a heavier the oversight duty, and other directors are under less the oversight duty?
Thank you so much, Rory. I really love this project. Continuing on the previous question, under Delaware law today, descriptively, all the directors share the exact same level of fiduciary duty, no matter their pre-existing expertise. Are you really calling for, not just in the Kermark context, but we can see like different incentives. If you do impose higher liability on the expert director, less people will want to serve as expert directors, and also maybe the other non-specialty directors will kind of be more laid back and say, oh, okay, we have the expert, so we don't really have to think about this problem. But if you don't put the higher level of liability, you also get like other bad incentives. So I wonder, where do you see the balance falling on this question? Thank you.
Okay, great paper, great discussion. Thank you so much. So I have two comments. The first one is whether you would consider, just to push the argument further, to look at a specialist overload. So are there, is there a complementarity or substitution, right? Like if you have an ESG, do you also need like a cyber? Like what is the, to look a little bit at that. And then related to that, to explore more the team dynamics and the structure in terms of looking at the skill matrix as a team, looking at director terms. Are we making the board larger? Are we replacing directors? Are we removing the audit, the legal, sorry, and putting a cyber? Are we, so what are the dynamics within the, and then where are we putting these experts? Are we, and who, are we putting, in which committees are we putting these experts? I think that would really enrich. And then my last point is, in terms of the board washing that you were talking about, there is research showing that boards that created CSR, ESG, sustainability committees, then if they were really, really serious, they also created the position of a chief sustainability officer. Like, so looking at one level down, they created a huge department on digital, on sustainability, on et cetera. Yeah, these are just comments. You don't have to respond.
Starting a bit late, so we're a little bit over time. How about we do 2 more questions and then let's respond? Okay, Jennifer and then Jen.
Yeah, thanks, Roy. Great paper. And I just want to raise something you and I have spoken about previously, but I think it follows on well from Kyung-Hun's comment and Asaf's comments. Just this idea that liability regime differences across jurisdictions are going to mean that this is not going to necessarily play out in any, consolidated or coherent way. And I was really fascinated by you saying that, the upping of potential liability under Caremark in recent times in the US has been seen as a reason why you have to have these specialist directors to make sure your oversight is good. The reverse happened in Australia. We had lots of specialist directors prior to the mid-1990s when Australian courts said all these directors, whether they're non-executive, independent or executive, are going to have the same duties, and we're going to throw the book at them for the duty of care, which is brought by a public regulator in Australia. So it can sort of play out in opposite ways.
That'll be our last question.
Yes, so thank you. So you stress a lot of reasons why so this additional expert might undermine the value created, sort of tunnel view, fake expertise, concession to tick more than one boxes, etc. But I think there is perhaps another reason why the value might decrease, which is about the dynamic in the group. And I think Ruth, touched upon that. And so, and you say, it's so board dependent and company dependent, etc. But what seems common to all these companies is that, there is a need for a dynamic. So perhaps what is actually needed, what you implied, is that there is a non-specialist director or a procedure director, someone who would be, helping with the mediation, and this is things you have, thought about in other contexts, sort of helping with this dynamic.
I'm seeing more questions. So again, in the interest of more feedback, less my time, I couldn't resist talking about Caremark. Somebody need to write an article about these developments. The point is not the scope of fiduciary duties. The point is how we assess fiduciary duties. And do we assess them individually, each director, or collectively at the board level? Now, normally, if we go breach of duty of loyalty, we go director by director. And if we go duty of care, we go collectively. And in Caremark specifically, we go collectively. Did the board collect the right information? Did the board react? And so on and so forth. So that's one thing. And I think it differs from, based on jurisdictions. This is the theme of this panel is mentioning Gann's paper. So I just read the paper on the TEPCO case, and there I'm seeing that they're holding only 4 out of 5 directors liable. So it might be different, but as things stands in Delaware, it's the entire board on Caremark. That relates also to Jennifer's point about the potential backlash. And a comment that we got from Adam Pritchard, who keeps always collecting data on litigation, is that he's seeing now in all the lawsuits being filed, the plaintiff's attorney specifically mentioning the expert director. So the company told us in the securities their disclosures that they added a safety expert, that they added a cyber expert, right? How come this cyber expert, where was this safety expert? Where was this cyber expert? So it could very well be that if these guys feel, even if there's no court decision, that these guys feel that there is increased liability exposure, there will be some sort of a backlash. Right now, the increase of board expertise disclosure, some of it is a ratcheting up effect, which is the company sends me form for the first time. They say, John or Roy, fill out, check the boxes in which you're expert. I'll probably only check the legal, right? And then I'll see everybody else, and I'm below average because everybody's checking 4 or 5 boxes. Next year, once they send me the questionnaire, I'm an expert on everything, right? So it could very well be that these developments in litigation 2 or 3 years from now will kind of, along the lines of what Fabrizio mentioned, will reduce it back to normal.